Namaste, I'm Priyanka Chakraborty and my co-host is Anil Agrawal. In this episode, we're unpacking the October 7 decision of the Honourable High Court of Kerala to grant interim stay by halting the collection of GST from Union Bank of India pensioners on their group health insurance premiums.
Right. That decision was colossal. It was a well-deserved and long overdue victory for beleaguered retirees who are having to cope with the rising cost of living, including health insurance costs, at a time when pension updation battle in the Supreme Court is stalled without any future date set for a hearing.
Okay, here is the core issue. Union Bank of India retirees were being charged 18% GST on their group medical insurance premiums, a move many saw as unjust, especially for senior citizens relying on fixed pensions without updation. The legal and constitutional pushback against the 2024 GST amendments came from the Honourable High Court of Kerala.
I think it's fair to surmise that Kerala just reminded the nation that the dignity of the elders of banking and other pensioners shouldn't be taxed for belonging to a mutual entity. Bottom line, Kerala says dignity is not taxable. That's a strong declaration and rallying call for bank retirees.
The petitioners in the Kerala case were Sri Vinod Mukundan and others, including the All India Union Bank Pensioners and Retirees Federation, AIUBPRF. The writ challenged the imposition of 18% GST, despite the clear intention and notifications of the GST Council, GST 2.0, to exempt individual health policies, including senior citizen policies, from GST.
The petitioners mounted a constitutional challenge, arguing that levying GST on retiree health schemes lacks legislative competence under Article 246A and violates Article 14, Equality, and Article 21, Right to Life.
The petitioners further cited a precedent in a related April 2025 ruling, during which the Kerala High Court declared certain provisions of the CGST and KGST Acts unconstitutional for overreaching legislative authority.
This judicial intervention represents a significant step in the struggle of retirees. It gives fresh momentum to the demands and strengthens the UFBU's position, asking central government to issue a binding clarification exempting bank retirees from GST. AIUBPRF et al. Are to be congratulated for bringing this case and successfully arguing its merits.
Looking ahead, this decision by the Honourable High Court of Kerala has clearly opened a can of worms, both for parliamentarians and the Indian Constitution. Notably, the stay has created policy pressure for government by adding momentum to calls for a zero-rated GST category for senior citizen health benefits.
Furthermore, older retirees mindful of their age and who have already paid health insurance premiums with GST want GST to be refunded to their pension accounts, following the Kerala High Court stay. This is to be expected because parity and a level playing field among bank retirees is essential.
Exactly. Our mission here is to really understand the wider ramifications of the Honourable High Court of Kerala ruling and to tease apart the related precedent case from April 2025 ruling, the Indian Medical Association versus the Union of India case, during which the Kerala High Court declared certain provisions of the CGST and KGST Acts unconstitutional for overreaching legislative authority.
Fascinating. So, on one side, you have the government trying to apply GST, goods and services tax retrospectively to transactions inside these associations and its members. And on the other side, you have this very old, very established legal idea called the doctrine of mutuality. This is a real tipping point moment for government and the Constitution.
Why do you say tipping point?
Because here's the modern GST system running into the headwind of the fundamental common law principle, a principle that shapes how these mutual benefit groups have worked for, well, generations. We are seeing the judiciary stepping in and essentially questioning what they saw as the legislature going too far.
Okay, so let's stop and start right there with that foundation, this doctrine of mutuality. Can you elaborate?
Sure, if you're a member, say, paying your membership fees or subscription, how does the law view that differently from, say, buying coffee from Cafe Coffee Day, CCD? What makes it mutual?
Duality, meaning two separate parties. You need duality for a supply under GST.
Exactly. The doctrine of mutuality says that, legally, bank retirees associations, clubs, and their members who contribute, they are treated as one single entity.
Correct. So, if they're one entity, any transaction between them is internal. Think of it like moving money from your savings account to your current account.
So that's the core idea, that you can't legally supply something to yourself.
Yes, it stays within. Now, GST, as defined in the Constitution, Article 3686 and 12A, needs a supply between two distinct persons, a supplier, a recipient.
If you only have one entity, that internal transfer just doesn't meet the definition. It lacks the required duality, so it can't be taxed like a normal commercial supply.
And the Supreme Court drew a very clear line way back in 1997 in the CIT Bihar Bankipur Club Ltd case.
It established what we call the tripartite test for mutuality. 3 conditions.
First, there has to be complete identity of contributors and beneficiaries. The people putting the money in must be the same group of people getting the benefits out.
Okay, number 2.
Second, there must be no profit motive in these member transactions. Surplus, any extra money generated, it has to be used for the association's main activities, its objectives, or eventually returned to the members. It can't be distributed like business profit.
Got it. No profit distribution. And the third?
The third is no transfer to third parties. The transactions, the benefits, they have to stay strictly within the membership circle, internal.
That closed loop seems key.
It is. It's this mutual setup, this financial circle that justifies the exemption.
And you mentioned earlier, this isn't something Parliament just wrote into the GST law recently. It's common law.
Absolutely critical point. This principle wasn't enacted by statute initially. It grew out of judicial interpretation over decades, even centuries, if you go back to English common law.
So judges developed it based on fairness and the nature of these organizations.
So judges developed it based on fairness and the reality that these associations exist for their members' mutual benefit, not primarily for commerce.
It has real historical weight.
Let's trace that history a bit, especially pre-GST. Before 2017, did courts consistently protect these associations from taxes like service tax or VAT?
Yes, always. The consistency is striking actually. It created a very high bar for the government. We saw it applied again and again under the old service tax and VAT regimes.
Any key cases there?
The big one everyone points to is the Supreme Court's decision in State of West Bengal versus Calcutta Club Limited. That was in 2019, although it dealt with the pre-GST era.
Right.
The Supreme Court explicitly held that supplies, whether goods or services, by a club to its own members weren't taxable under the state sales tax or VAT laws.
And why not?
Because, the court said, the principle of mutuality applied and the existing state laws hadn't specifically overridden it. That logic was then directly extended to protect clubs from service tax too.
Several high courts followed suit, like in the Ranchi Club and Sports Club of Gujarat cases.
Okay, so for decades, right up to the highest court, the judiciary built this protective and strong wall around mutual associations based on this doctrine.
Which leads to the obvious question, what changed? If the courts consistently said no tax, what did the government do under the GST regime to try and suddenly bring these transactions into the tax net?
The shift or the attempted shift happened after GST was introduced in July 2017. Initially, the main definition of supply in Section 7(1) of the Central GST Act, well, it didn't explicitly target these member transactions, respecting the status quo.
You could argue that, yes, it implicitly seemed to follow the established legal understanding.
But then came the Finance Act 2021. That's where the conflict really ignited.
What did that act do?
Parliament inserted a new clause, Section 7(1), directly into the CGST Act. This clause specifically stated that activities or transactions between an association or club and its members would be considered a supply.
Wow. So they weren't just changing the rules for the future. The government was trying to rewrite history and demand potentially years of back taxes based on a law that didn't even exist at the time those transactions happened.
Precisely. It was a clear attempt to legislatively nullify the doctrine of mutuality for GST purposes retrospectively.
Well, they didn't stop there. They also tweaked the definition of business in the Act Section 217 to specifically include providing facilities or benefits to members by a club or association.
So, a two-pronged attack essentially. Redefine supply and redefine business to capture these internal activities.
But the court's view ultimately was that changing something so fundamental, overriding a core common law principle tied to the very definition of supply under the constitutional framework of GST, requires more than just a regular law.
It touches the Constitution itself, doesn't it?
That was the argument. And this legislative move is exactly what pushed the IMA in Kerala to go to court when they started receiving tax demand notices based on this retrospective change.
Okay, makes sense. So that brings us to the Kerala High Court's decision in April 2025. What did the judges actually find? What were the key takeaways from that ruling?
The High Court, specifically a division bench, came down very strongly. First, they explicitly reaffirmed the supremacy of the doctrine of mutuality in this context.
Okay,
As I recall, the Kerala court stated quite clearly that a members' club fundamentally cannot supply services to itself or its members because that essential element of duality, two separate entities, is missing.
so they upheld the core logic we discussed earlier.
They did. They recognized that the 2021 amendment, Section 7.1, directly contradicted this established legal principle.
Okay,
And because of that contradiction,
the court's main conclusion was legally explosive. They declared Section 7 were 1, unconstitutional and ultra vires,
ultra-virus, what does that really mean?
acting beyond one's legal power or authority. Essentially, the court ruled that Parliament had acted beyond its legislative competence when it enacted that specific provision in that manner.
Wow. So not just disagreeing with the policy, but saying Parliament didn't have the power to make that specific change through a simple amendment to the GST Act.
Precisely. The court's reasoning was that if you want to fundamentally alter the scope of supply to override a principle like mutuality, which is deeply embedded in the legal understanding underpinning indirect taxation, that kind of fundamental change, you'd need to change the constitutional framework that defines GST itself.
Right now, the question probably on the mind of bank retirees living outside Kerala is what does this mean for me? If you're in Mumbai, Delhi, Chennai, does this Kerala High Court ruling actually help you? Is it a nationwide shield?
The answer is no. A high court's judgment is strictly binding only within its own geographical territory. So within Kerala in this case.
However, when a high court strikes down a central legislation, like part of the CGST Act, on grounds of unconstitutionality, that decision carries immense persuasive weight across the entire country because of the need for uniformity in law concerning central acts of legislation.
Meaning other courts are likely to follow it. And while another high court isn't strictly bound to follow the Kerala ruling, they will give it enormous respect and deference. It becomes a very powerful precedent for any similar challenge elsewhere in India.
So, until the Supreme Court rules definitively on the matter, the Kerala High Court's judgment serves as a very strong indicator of the likely legal position.
Right. So where are we now? Has the government just accepted this ruling? Have they withdrawn the amendment?
Oh, definitely not. Acceptance is not on the cards here. The Union of India swiftly filed a special leave petition, an SLP, challenging the Kerala High Court decision before the Supreme Court.
The case numbers, for those tracking, are SLP Civil 00134918350 of 2025. It's now pending before the Supreme Court. And crucially, no stay on the Kerala ruling has been granted by the Supreme Court as of the time of this podcast.
Meaning, the Kerala High Court's judgment that Section 7.1 is unconstitutional and these retrospective demands are invalid remains the effective law of the land. For now, even with the appeal pending.
Okay, so let's try and synthesize this. What's the big takeaway from this entire saga for bank retirees and GST?
Okay, so let's try and synthesize this. What's the big takeaway from this entire saga? Firstly, I think the clearest takeaway is that bank retirees in Kerala have already received relief from GST. Secondly, bank retirees elsewhere in India must await the outcome of the Supreme Court.
Well, that's all the time we have for this deep dive. We hope this gives you a much clearer picture of this complex but crucial legal battle over GST and the doctrine of mutuality. Before you go, please share, like, and subscribe.